Alright guys, what starts as a routine court hearing quickly spirals into chaos. A mother pleads for mercy, a judge explodes with emotion, and what happens next? No one saw coming.
I'm saying the court had asked us to approach and talked about bond.
Because I'm putting everybody on notice where I am. That's why. Go ahead. You want to come at me? Let's do it.
Judge, I'm making a record as to.
No, go ahead and make your record. I'm just telling you where I am. Court calls case People versus Courtney Walck.
What happened with Courtney Walck? Judge, this is date and time set for our second probable cause conference. At this time, Ms. Walck is inclined to waive her right to preliminary exam, and we've gone over those rights.
Walck, is that correct? You're waiving your right to a preliminary exam?
Yes, Your Honor, we do. And if that's the date, I'd like to address bond at the appropriate time.
Pardon?
Yes, I do waive, but in case this affects her pretrial date, I'd like to address bond at the appropriate time.
All right. So before I set the date, you may address bond. Go ahead.
Your Honor, at the time my office charged this case, we requested a $100,000 cash surety bond. At this time, I am renewing that request. I understand that Ms. Walck was given a $50,000 10% bond at the time of her arraignment. When we were last before Your Honor, I did not have the benefit of certainly I still don't have the report because the investigation continues to be ongoing. However, the information that is now available to me has grown substantially since we were last. On January 20th, the day of the crash, Ms. Walck had been to a baby shower. She then went to Ray's in Ypsilanti with her friends where she was drinking with her friends. She was texting people that were not present, somebody who was either her friend or her boyfriend. She had texted things to her boyfriend about meeting up with him later. In her text messages to her boyfriend, she indicated that she was out drinking with her friends and that she would be continuing to be drinking with her friends. She referenced to him that she wouldn't feel comfortable driving too far to meet him later, and I apologize for my language, but that she was going to be really hopped up. She did drive instead, though. She drove her car and she killed Miss Mason. After getting home, she didn't stop. She did not call the police, and she left Miss Mason there. After getting home,
In a Milwaukee courtroom, an unexpected storm is brewing. James Pooh, charged with serious felonies, appears before Judge Rosa, but it's not just his case that grabs attention, it's his mother. With trembling hands and heavy heart, she rises to speak. Her voice cracks as she pleads for her son's freedom, painting a picture of hardship, heartbreak, and helplessness. The room shifts, tension builds. Everyone braces for what this emotional plea might unleash.
Miss Walck saw her roommate's name was Sarah. Now, notably, we now know that Sarah actually drove that same route as Courtney a couple minutes ahead. And Sarah did see Miss Mason alive and walking on the road. And Sarah initially told the police that she saw Miss Mason walking on the shoulder of the road, which is consistent with physical evidence in this case as well. But when Courtney got home, and this is sort of like Sarah's statement, as I understand it, as well as from the text messages that followed this, Courtney was quite hysterical. I'm going to call her Courtney. Courtney told Sarah that she had hit someone and that she needed to go back. Courtney and her roommate took over an hour to return to the scene. During this time, Courtney did not call the weather. When Courtney came in for her interview with the police, which mind you was the Friday following, so she came in for her interview on January 26th. The crash occurred on January 20th. She told the police that she believed that she hit a deer. This deer had just kind of popped out of nowhere, that she saw it just coming at her. We know from our interview with Sarah, the roommate, that Miss Mason was walking down the road. Sarah saw Miss Mason a couple minutes ahead of Courtney, and that Miss Mason was walking down the road. But what we also know is that Courtney didn't think she hit a deer. Sarah has now told us that Courtney came home and said, I think I hit someone. Sarah has confirmed for us that there was no mention of a deer. So when Courtney got home, thinking that she hit someone without calling the police or stopping to help that someone, she continued to tell her friends and her family what she had done and what stress she was under. She didn't call the police, leaving Miss Mason lying.
Judge Rosa listens, her expression unreadable. But then, she leans forward. Her voice cuts through the silence. She doesn't just push back, she erupts. The judge blasts the mother for enabling her son's crimes, calling out the lies, the manipulation, and the broken justice. You think this is about a mistake? She snaps. Your son terrorized people. The courtroom stirs. Her fury is real, and it's aimed straight at the heart of a mother's plea.
That if Courtney had just called the police, Miss Mason might still be alive. That's why we have crimes like this. That's why the penalties for crimes like this are so substantial, because Miss Mason may have still been alive and may still be with us right now. Miss Mason was a mother, she was a daughter, and she was a grandmother. And that woman was left on the side of the road without anybody called, with any help being sent her way. But not only did Courtney not call the police and not attempt to save Miss Mason in any way, what I now know is that Courtney then deleted approximately 150 messages on her phone. What she also did when she got home, and I know that defense counsel will argue that this was normal for her behavior, was she parked her vehicle in her garage. That car remained in the garage, and the garage door remained closed, as far as I understand it, with the garage inside. The police subsequently did a search warrant, and it wasn't until they were there with the search warrant that they were then given consent to go into the garage and discover the Jeep.
Response.
Thank you, Judge. Obviously, I don't have to tell the court that Ms. Waldick stands here before you innocent until proven guilty. I'm not going to try the case in front of you, but I will address some of the things that were just said. First and foremost, there was an arraignment on January 28th where, as Ms. Hughes indicated, their office requested a $100,000 bond. A record was made. Prosecutor who attended the Zoom arraignment on that Sunday, myself, each made a record, and bond was set at $50,000, 10% with an alcohol tether. It's our argument to the court that that was not an unreasonable bond, nor was it an abuse of discretion. The fact that there's an ongoing investigation or this was charged early, that's not my client's fault. Maybe the prosecutor's office should have waited until the investigation was complete. With that said, Ms. Hughes indicates there was some drinking going on. My client turned herself in as a person of possible interest to the Washtenaw County Sheriff's Department to Detective Webb on January 26th.
Things only escalate. Judge Rosa unloads a chilling list. Victims beaten, lives destroyed, evidence irrefutable. James didn't just break the law, he shattered it. And yet, here his mother stands, defending the indefensible. The judge's voice trembles, not from fear, but rage. Where was your sympathy for the victims? She roars. Where was your justice then? The courtroom is stunned. What began as compassion has now exploded into a war of truth.
Same Sarah who said she knew nothing about this originally. So now we have two different stories from Sarah, because originally Sarah said she had no idea what happened on the date in question. Ms. Waldick is now, since the arraignment, been before you twice here on February 22nd for her. She's been compliant with bond the whole 2 months to today's date that she has been on bond since being arraigned, with an alcohol tether the whole time before she was released from jail, with absolutely no issues. So this is the second time before you, but including going to the Sheriff's Department to speak to Detective Webb, she's appeared 3 times. She's not a flight risk. In addition to being on alcohol tether and having no issues, she's also reporting, checking into community corrections weekly. I've heard nothing today regarding any bond violations because I don't think there are any. There's been no change in circumstances as we see it since the date of the arraignment. Ms. Waldick is definitely not a flight risk, and she's not shown that she's a danger to the community in the past 2 months at all. Again, there's been no allegations of that. Judge, the 8th Amendment of the U.S. Constitution indicates that the court shall provide a bail that is not excessive. Stack versus Boyle, 342 U.S. 1 in People versus Edmond, 81 Mishap 743 says bail that is set in an amount higher than reasonably calculated to give adequate assurance that the accused will appear is excessive under the Eighth Amendment. Edmond goes on to say that courts have held that money bail is excessive if it is in an amount greater than reasonably necessary to adequately assure that the accused will appear when her presence is required. Court rules are designed to enforce these principles, Judge, and under these rules, there's a double presumption that a pretrial arrestee will be released without any case. Neither party had asked to address bond, but you had mentioned it.
Well, counsel, if you want to point at me, I'll tell you exactly what I know about this case. What I know about this case is the warrants came to me. That's how I knew. And that it came to me because I'm in charge of all of these felonies and reviewing every bond that comes through. So that's how it came to me. So if you want to make dispersions against the court, go for it. Let's roll.
I'm not making dispersions. I'm saying the court had asked us to approach and talked about bond.
Because I'm putting everybody on notice where I am. That's why. Go ahead. You want to come at me? Let's do it.
Judge, I'm making a record as to.
No, go ahead and make your record. I'm just telling you where I am.
In addition, and obviously we know that search warrants aren't necessarily evidence. I appreciate that you know things or allege things because you were a party to the search warrants. In addition to what I've already indicated in terms of bond, she's not a flight risk. She's appeared at every court appearance. She's gone to the sheriff's department, met with Detective Webb. She consented to a release of and a search of her phone. She doesn't have any shown history of substance abuse or addiction, a mental condition. She's employed thankfully at a local hospital. She's got family members here. She's probably got about 5 family members here. She lives locally. She's got ties to the community. Again, bond is set at protecting the community and a flight risk. I think that what she has shown over the course of the past 2 months is she's neither. I'd ask that bond stay the same. Thank you.
From the people.
Nothing further, Your Honor. Thank you.
The court, in looking at the file until that the record is clear, counsel came to the bench and the court was apprising counsel that the court had some concerns with the bond that was set. Neither counsel at that time was ready to raise the bond. They were certain.
But then comes the pivot. Judge Rosa pauses. She speaks of society's failure, of families torn, communities wounded, cycles never broken. She's not just condemning James. She's condemning the system. The air turns heavy. Her words are no longer just scolding, they're haunting. This isn't just your failure, she says. It's ours too. That moment lands like a gut punch. It's no longer a trial, it's a mirror held up to the pain we ignore.
The court's attention that were not in the magistrate's mind, nor the magistrate's information at the time of the arraignment. I brought that to counsel's attention, quite frankly, out of fairness to both sides so that it could probably be argued before the court. What was not known, certainly, the magistrate at the time was that there was this delay. There was information that was provided to the magistrate at the time regarding the defendant turning herself in, which was somewhat confusing as to how that occurred. And I apprise counsel of that. What my initial conclusion or what I saw was based upon what was presented to me prior to that hearing. Additionally, since that time, something that was not available to the magistrate were these text messages, which lead also to the defendant's knowledge, which play into this court's mind as to this defendant's danger to the public. Furthermore, there is, in terms of the issue of flight, of concealment of evidence and the like, now the deletion of text messages and other evidence in this case, which have just been alluded to, the deletion of basically evidence, which I think also bears upon the defendant's risk in this case. Also, the likelihood, the court can take into account the likelihood of conviction and other things as it regards to setting a bond. But certainly there is now clearly more information that's available to the court regarding this defendant.
James Pooh remains stone-faced. His mother, now quiet, watches as the judge delivers the sentence. There's no drama, just devastation. Years behind bars? No second chances. The judge locks eyes with him one last time. You chose violence, she says. And now, you'll live with it. The room is silent. Justice, however brutal, is delivered. And what started as a mother's plea ends in a cold, legal reckoning that can't be undone.
The offense that was committed and the like. The court, I will also take into account the fact that I don't have any community corrections violations. I don't have anything along those lines. I do not believe that, given the information now available to the court, that the amount of the bond that was originally set, I do not believe that it is appropriate, and that additional bond would be required in this case. Defendant's bond, Mr. Allen. The defendant's bond in this case will be increased. I think that the amount requested by the people was an appropriate amount. Quite frankly, it was appropriate, but now knowing what I know, I would actually raise it beyond that, but I will not do so. In this case, her bond will be increased from $50,000 cash surety to $100,000 cash surety. Are they, counsel, just for the purposes of anything, are they able to do that right now? Or
We've made arrangements. There's a surety bondsman in the courtroom who can do that. If you can give us 15 to 20 minutes, it'll be taken care of.
she'll be taken back and do that? I think they can do that.
Hold on, sorry guys. We need to arraign her on the information. I apologize. I interrupted all of our proceedings.
Oh, okay. Yes, that's to the circuit court.
As the gavel drops, the courtroom empties. But the echoes remain. This wasn't just a hearing. It was a raw, public confrontation with accountability. The judge walks out, carrying the weight of every broken story she's ever heard. Viewers across the world now debate, was she too harsh, or finally honest? One thing's certain, when truth and pain collide in court, the verdict shakes more than just the accused. It shakes all of us watching.